Hi, it's Mike DelSignore. I want to talk about some recent wins I've had in the last 2 months. 2 third offense OUIs, 2 clients found not guilty. Here's what we did. Both cases had to go to trial to avoid a conviction. One case in Middlesex County, the other one in Essex County. So what happened? What was the strategy? What was the approach? So first thing we tried to do when the case came in, tried to give the client the option of resolving the case short of trial. Wanted to see if there's a possibility they would reduce it to a second offense, avoid the risk of jail time. Both clients did a great job with treatment, counseling. They did everything they could, and ultimately the DA said, no, we're not reducing it. I've had plenty of cases where they've been willing to reduce the charge, but these 2 cases, both DA's office, one from Middlesex, the other from Essex, did not agree to reduce the charge. Middlesex would have reduced it to a second offense, but still wanted some jail time, whereas Essex County said no reduction at all, take the third offense or go to trial. So they offered the minimum on a third offense. So what was the key to success in both cases? So in both matters, what I did was I first attacked the field sobriety tests. In one of the cases, the case from Essex County, there was some field sobriety tests, pointed out that those are not accurate, reliable indicators of impairment. Showed that a lot of things my client did were inconsistent with impairment, and also attacked the driving, saying that, the driving, there was no accident, no calls from the public. So the driving had characteristics that, while maybe resulted in my client being stopped, but not enough to say he's impaired. So what I did was I focused on the positive. In my experience, and what I do for my clients is I always want to focus really on the strength of our case, and then do the best we can to diminish their case, but really focus on building our theory, showing a judge or jury why we think the evidence raises a reasonable doubt. And we don't need to win every point. So we can lose some points. They can score some points, so to speak. There can be some bad driving. There can be some missteps on a field sobriety test. But that doesn't get them to beyond a reasonable doubt. In this case, the client was, the evidence at trial was he was very polite, cooperative, respectful, was able to have this client from Essex County found not guilty, avoid jail on an OUI, third offense, major victory for him. The other client, Middlesex County, family, great job, had life-changing consequences if he got jail time. So stakes could not have been higher. He also got his license back. So you can get your license back. It's a 5-year suspension for a breath test, refusal on a third offense. If the judge allows the motion, in this case they did, it reinstates on the 5-year refusal. So amazing outcome in this case as well. Key to that case was there's some civilian witnesses attacking their credibility. Knowing when not to mix it up with some civilians. Sometimes you have a witness, they're going to hurt you a little bit, but as a defense attorney, you can do more damage than good sometimes by asking questions. So it's one of the skills that I've learned. I've been doing this for 20 years. It's sometimes hard to do not when to ask a question. I think that actually is sometimes the best thing a lawyer can do is don't make the situation worse. Don't attack a witness where they're not going to help you. We had other witnesses, other evidence in our favor, video evidence that showed our client wasn't impaired. There was demeanor evidence, other officers, testimony we got from other officers that showed this didn't seem like somebody drunk. They did not seem like they were handling it as somebody under the influence. So what happens is when the officers come to court, they're going to testify slurred speech, odor of alcohol. But sometimes you have a video and it paints a different picture. You see in this case, you saw how the client interacted with the police, how the police interacted. It did not seem like there was urgency. It didn't seem like anyone thought he was drunk. There was no, we're dealing with somebody intoxicated. So when you have a video, sometimes you can say, geez, these cops aren't bashful. They're talking about everything else under the sun. Nobody said this guy was drunk. So you can use that to create reasonable doubt. So third offense OUI, you need a lawyer to take these cases to trial. That's what I do. I love doing it. I love helping my clients get their life back together, do whatever they can. In both of these cases, great people. From day one, they listened to me. I told them, get alcohol treatment. They understand, and I explained to them that's never an admission. No one's ever going to say you're guilty because you're doing alcohol treatment, but it might either A, save you from jail, B, reduce the time, so there's no downside from it. No one's ever going to say you're drunk because you did some kind of treatment. It definitely helps the case. It's helped a lot of my clients get a lot of times I have been able to get a reduction to a second offense. In Bristol, Norfolk County, been highly successful getting third offense charges reduced. Sometimes the DAs, for whatever reason, say, no, we're going to fight this, and we want either the third offense conviction, you get a not guilty, fine, you get a not guilty, but we're not going to be on the record as reducing it. So this is my passion, helping people charged with OUI cases. Been doing this for 20 years. Call, text anytime. My name is Mike DelSignore, 781-686-5924.